And welcome. I hope everyone is happy here today, and I hope everyone can hear me all right. Let me do a sound check. All right. So, wow. Well, it seems like we just saw each other only hours ago. But welcome to everyone who is coming on in. We have some important things to get to today, and today is the yearly circling around to February 14, which we know is a an important day um, in discussing this Abby and Libby travesty, and so we want to recognize that before getting started, and also it's a little unexpected because what I plan to do today I'm putting off until later this evening because this came up and this is very important. And so we got to get into this particular aspect because it's informative, I guess. What has happened is that the state, I'm sorry, the defense for Richard Allen, and by that I mean Mr. Andy Baldwin, has filed a motion to strike, or better known as a defendant's verified motion to strike the state's response to motion to correct error. So I want to go through that today very thoroughly. And I'm aware that some of you may have already gone and gotten a taste of it from some other channels, and that's fine as well. I hope that you read it for yourself. It's all good to get informed on this. And so today we'll go through it. I'll give you my take on it, and hopefully the chat will also have some comments. So that's what we'll be up to. And then we will delay till later our planned content for the evening. So let me do this. Let me there's one thing I forgot to do in the rush to get here. So let me take a look. I wanted to take a look at something and make sure that there's not something that I want to get into. So let's see. Let me make sure I clear this. Sort of have to clear the options here and make sure that I'm not missing potential for you guys. Let's see. No, I don't want to take a poll. All right. All right. So as usual, the dickheads at Reddit are ignoring the fact that I'm covering this, which is what they always do, is pretend this channel doesn't exist, which shows you they're not interested in the truth about Delphi. They're only interested in pushing their own narrative. But we'll let them do that, and we'll do what we do. Let's see. So before we get started, let me say a quick hello to everyone in here. And we'll be getting into it. So welcome to Elizabeth Park. Okay. Oleg Cat. Barbara Borman. Don McKenzie. Tony Hunt. Spicy Cappy. Charisma 6174. Say What. Donnie Pitbull Kuntz. Mark Ellis. Cherry Pops. L'Oreal. Criminal Network. David Rogers. Dirty Diana. Faith Ross. Who's Your Daddy 11. Bonnie. Brandola. Girl. Kayla. KP. Dennis McKean. Judge Jessica. Megan. My Vintage Shabby Shop. Jake Brooks. Swade Smith. Debbie Packer. Deb. Miss K. TJ Bits. Plain Iron. ACV. Shiloh. Kalida Hope. Music Man. Sarah. Who else we're here with? Kelly. Sweet Dude Shibby. Santana Treto. Teresa Manning. Mar R. MJ Lewis 1964. Court of Public Opinion. Jamie Blair. All right. Shiboogies. Yes, exactly. Catastrophe. Okay. Jalen. Texas Lady 1025. Well, you know, oddly enough, ACV, it's the same Reddit that that doesn't ever discuss any sort of suspicions about the family. Oddly enough, the one thing they ever refuse to do is question the family, but then they also, oddly enough, don't acknowledge the fact that we do work here. Texas Lady 1025, Sergeant Mike 1972, Kathy S, Tony Hunt. Okay. Lisa. Deanna Burdette. All right. And that may or may not be everyone. Oh, welcome. It's Sunflower as well. All right. So, you know, there's a growing rift in the defense side over here, if it's not clear to you already, it should be clear to you. There's a growing rift in the defense side over here, and it's not only between me and others, it's also behind the scenes between some of the investigators and attorneys, and there is a growing rift in the defense side, and it's somewhat of a political rift, but it's also a theory-based rift that you need to be aware of. The sort of the division between, is this cartel or criminal underworld tied, or is this solo Ron Lone Wolf, Ron Logan Lone Wolf killers type of crime? And I think that growing rift is going to become more and more widened. So get ready now that we're moving into a time where you're going to see factions break off. And the problem is that I've said from the beginning, we've got controlled opposition. Okay, we've got controlled opposition. And I've said that from the beginning. But my focus has been on the troll farm, as you know. And I don't know if any of you have caught this yet, but, you know, today being the anniversary of the finding of the bodies of Abby and Libby, I think it's pretty interesting because I don't know if you notice, but it's just really odd that those same individuals from the troll farm who have for years threatened to kill us, kill our families, intimidated, been the most hateful individuals, physically assaulting some of us, threatening to have us sued, arrested, talking about and slandering my dead brother. Yes, these very nasty, evil, disgusting individuals today, even with all of that behind them, they have the nerve to post little flattering 30-second videos in memory of Abby and Libby with a little pleasing heavenly music, basically gaslighting the hell out of the entire community as if they've always stood for that sort of energy being injected into the community, when they have injected nothing but hate, anxiety, stress, intimidation, doxing, death threats, etc. But it's just so funny that that just like Nicholas McClelland, they love to gaslight the public. So instead of continuing on with the hate, they choose this day to just appear to be the most loving, compassionate, and conscientious victim advocates. And that's these people. And man, every time they post something, it's there's never a dull moment. Every time they post something, it's just amazing to see what they're doing and how they do things. But you know, like I said, Nicholas McClelland did it himself. Remember, at the closing, what he chose to do to the jury was to traumatize them with gore. He traumatized the jury with gore, and then he painted those victims as the most heroic, lily white, flawless, and insinuating the entire time that Richard Allen is the one who did that to them. And we saw the Patties recently do that. They said yes, there's been all this confusion, but if Richard Allen would just say what he did, or just confess, or just apologize, or just do this, so they love to blame the attorneys for Richard Allen for all the wrong things, and then to imply that Richard Allen is absolutely guilty and just needs to go ahead and apologize for what he did to the girls. And well, hell, one thing we know for sure is that they have railroaded Richard Allen. They have not produced any evidence that he's guilty of this crime. And at the same time, they tried to jail the attorneys for Richard Allen, just like they tried to jail Todd Click and others, including Mr. Kyle Fortson, who is dead now. And that's after forcing them to remove themselves from the case with the threat of public shaming, um, a effort in which the Supreme Court of Indiana had to intervene. So you know how it is. You know how it is, and there will forever be a gulf between these parties, and and I got to say, this growing gulf on the part of the defense, I feel it's going to be a permanent gulf as well, because the thing is that forbidden speech regarding the Delphi murders, or regarding any murders, or regarding politics, um, the time is coming to an end for this sort of thing. So the cancel culture, the forbidding of speech, the shaming of people who dare to question and bring up forbidden talking points, it's time for all of those things to end. And as I've said so many times before, this is my platform where I exercise an absolute dictatorship. But in general, speech is allowed. Okay, it always should be allowed, because speech is so much less threatening than action, and we know that we prefer people to be able to freely exercise their speech rather than to take their vendettas to the streets and exercise through actions. And so that's why speech should be allowed, so that the public has an outlet. And I just don't understand how those positioning themselves, or pretending to advocate for a certain cause, would ignore the obvious elephant in the room. And that's the problem with the defense sympathizers at this moment, is there is an obvious elephant in the room. And if we cannot really see that obvious elephant in the room and discuss it, then we're doing nothing. We're not doing anything better than the prosecution shills, who are also ignoring the elephant in the room. And hell, I think I've covered that elephant in the room quite well. And I think all of you understand. And special shout out to True Crime Design, my self-proclaimed, I am proclaiming her my partner in crime, although we have nothing to do with working together. We just coincidentally align. And True Crime Design, one of the standouts here, who is not afraid to call it as she sees it. And that takes a lot of balls. Takes a lot of balls, because you know, there's lots of things that are not favored in saying, and we all know that questioning the family is career suicide, which is why the attorneys don't do it. And if you've wondered, why haven't the attorneys questioned the family? Why haven't the defense investigators questioned the family? Why haven't all these people questioned the family and brought up these very pertinent points? Well, it's suicide. And so it takes a special type to brave that. And I want to send a shout out to her and to all the others, and everyone in the chat who is braving the storm. Okay, so yes, God bless you all, and so I'm gonna open up with a reading of the local news coverage of today's action, and then we're going to get headlong into our presentation, so that we inform ourselves about all the context and the details of this, so that as you leave, you're more informed than most to be able to understand and also argue your points. So this says, a fiery rebuttal. The attorneys representing convicted murderer Richard Allen floated the idea that Carroll County prosecutor Nicholas McClelland should be held in criminal contempt for releasing crime scene photographs from the Delphi murders. Last week, McClelland released photographs of Liberty German's cell phone, which had previously never been seen outside the courtroom. These images were included as part of the state's rebuke to claims made by Allen's defense team, who continue to push for the conviction against their client to be vacated. Allen was found guilty in November of causing the deaths of Libby German and Abby Williams. In the whole high-profile case, which garnered national attention, the jury was kept from any mention or knowledge of third-party suspects, alternative theories of the crime, and much information that had been lost or destroyed over the years. This ended with Allen being convicted by a jury. Remember, after 19 hours of deliberation, and if the juror who has come public, which is in question in and of itself, is correct, it was not a very convincing case made to the jury, and it was barely achieved, this unanimous guilty verdict. But as time passes, we have more and more reason to believe that this juror may not have been a true juror or jury member. I mean, don't you find it odd that of 12 individuals, now months later, we yet have no one to come forward? Only one very flaky, immature, fickle, unconvincing, it was very unflattering look on the juror's part who did come through or come across. And I just wonder, where are these other jurors? Where are these other jurors? But that being said, Allen's defense team vowed to appeal the conviction and reignited debate around the case by filing a motion to correct error. Here on the Prof's channel, we've covered this motion to correct error just not too long ago. Perhaps it was 10 days ago, we covered the motion to correct error. And we also included in that the state's response to the motion to correct error. And now today, we have a verified motion to strike the state's response to that motion to correct error. Now, this motion to correct error pushed for Allen's conviction to be vacated for various reasons, including a purported confession made by Ron Logan, the owner of the property where the girls' bodies were found, and disputes about the state's timeline surrounding a passing van that proved key in the case. And that's where I'm latching on to. You know, I'm not very convinced, or I don't find the Ron Logan alleged confessions very compelling, but nevertheless, McClelland fired back against the motion to correct error with his own rebuttal last week. And now the legal sparring continues, with the defense once again punching back at McClelland, rightfully so, crying foul about his responses and claims, even floating the idea that the court should hold McClelland in criminal contempt. Oh, a phrase that is music to my ears. Just music to my ears, I must say. And you're going to learn today that these unverified claims are really the substance of the matter, but we'll be getting into that. Quote, The court might want to consider whether to hold Mr. McLeland in direct criminal contempt for publicly filing crime scene photographs that the court ordered sealed at Mr. McLeland's own request. Allen's defense team mused in their most recent filing. Alternatively, the court might consider issuing a rule to show cause why Mr. McLeland should not be held in indirect criminal contempt for his willful violation of an order of this court. But as I've said in my past live streams, it's very obvious that what Mr. McLeland does is he uses what he wants when it's behooving of him to do so. So if he wanted to try to discredit Miss Stacey Eldridge and her expert opinion on the phone, he's going to go ahead and do whatever he wants because he feels absolute impunity. And trust me, all of these parties in Delphi, it should be very clear to all of you at this point in time that they feel absolutely invincible or immune to any sort of accountability. Remember, I've said that it's very disturbing, all of the things that transpired in the attempt to have Mr. Richard Allen arrested and then subsequently to have him placed in Westville where they knew he would be tortured and abused. Going back to the fact that this judge drafted the safekeeping request for Mr. Lesenby, which in and of itself is not it's not appropriate at all, in violation of the rules of judicial conduct of Indiana. And then in his own court, he signed his own request for safekeeping, all done outside of any service to Richard Allen or his attorney, and ignoring the fact that he had indeed retained counsel. There's so many aspects to this. They've behaved with absolute malfeasance, bad faith, and they think they are free to do as they've probably always done. Okay, in that small jurisdiction, and you know that's how it goes in these tiny towns. That they do what they've always done. They've always had backroom deals. They've always had dinner with the judge and decided what to do. They've always colluded, cooperated, railroaded, destroyed evidence. It's the way that things happen. It's only in this day and age that accountability is starting to come and transparency is starting to be demanded, and constitutionality is starting to be forced. But we're going to continue to have to fight because this is so ingrained in the culture that it's only when they are forced with the consequences of criminal indictment to change these behaviors that they're actually going to change. And that should pretty much be obvious to everyone. But it's worth noting that McLeland once again called for Allen's attorneys to be held in contempt due to a leak from the defense attorney's office, which led to crime scene photographs making their way online. And you saw the Patties just do the same thing. They blamed, once again, they blamed the attorneys for that, when we know the attorneys were the victims of a crime. Let's be honest here. Whether or not Andy Baldwin likes Mitchell Westerman or not is of no import. Mr. Baldwin was the victim of a crime committed by Mr. Westerman. So, since when is it okay for prosecutors and the families of the families of victims to engage in their own form of victim blaming? Remember, any attempt to blame Mr. Baldwin for Mr. Westerman's criminal actions in stealing the crime scene photographs from his office, it's an act of victim blaming. But the family is okay with that, just like the family is okay with the railroading of Richard Allen and the clear bias of the judge. And any opportunity they've had since the gag order has lifted, they have doubled down and reiterated that fact. And it says here, the suggestion of criminal sanctions against the prosecutor is floated as a footnote. It's funny. It's fun. Honestly, I laughed. I laughed when I read it. But in Attorney Baldwin's latest motion filed on behalf of his client, the motion calls upon the court to strike McClelland's rebuttal from the record while disputing claims made by McClelland in response to the motion to correct error. Baldwin also pushed once more for Allen's conviction to be vacated. One of the main sticking points of Baldwin's latest filing is McClelland's claim that the motion to correct error be thrown out due to no newly discovered evidence being presented. McClelland argued multiple times in his rebuttal that information brought forth by the defense team, including the alleged confession by Logan, was not new and had always been at the disposal of the defense team by being included in discovery materials. The simplest answer is that a motion to correct error only applies to newly discovered evidence, McClelland wrote. From the defense's own admissions, this is not newly discovered evidence, but rather evidence they had been provided long before trial. But Baldwin says McClelland's assertion is erroneous and argues that trial rule allows for a motion to correct error to be filed based on evidence outside the record. And we're going to learn about that momentarily. Logan's purported confession disputes in the timeline regarding Brad Weber's white van, arguments about German's phone. All of these things, Baldwin argues, fall within the evidence outside the record due to never being presented in court. McClelland argued previously that the defense team chose not to present this information in court despite having it at their disposal. This legal sparring raises questions about if a defense team can purposely not present evidence into record and later invoke the same unpresented evidence as cause for a conviction to be overturned. But the defense team claimed some of this evidence wasn't provided. In the most recent filing, the defense claimed not to have seen any exhibits that mention Davis taking a polygraph test, which McClelland claimed the inmate failed. The defense team also argued that McClelland's rebuttal mixed up claims about Logan's alleged confession. McClelland stated part of the purported confession included Logan telling Davis he burned the girl's clothes in a fire pit, but the defense pointed out correctly that the original claim stated Logan told Davis he burned his own clothes in the pit, not the girl's. We're going to be getting to that. McClelland pointed out in his rebuttal that Logan told Davis he took the battery out of Libby's phone, which doesn't align with physical evidence and discredits that confession. But the defense claim that they have not seen any exhibits that mention Logan confessing to removing a phone battery. Yes, it's a shit show to be sure. While the court might take McClelland's misstatement of fact about the burning of clothes as simply a mix-up, either McClelland is making up allegations or he has access to information about Ron Logan that he has not shared with the defense. Okay? And that's pretty much the summary of the biased article there, but I just wanted to use that as an introduction. This has been a complete circus, and it continues to be a circus. But as I've said from the very beginning, and it just continues to prove to be true, that in every instance, the defense team's claims and statements of fact continue to prove to be more compelling, ring more true, and more backed by evidence, verified by evidence, than the prosecution's gross mischaracterizations and general glossing over pertinent points, ignoring anything that would seem to discredit their claims. As time goes on, the prosecutor or prosecution continues to discredit themselves more and more and more. And no matter how many times these troll farm post photos of the victims with beautiful phrases, uh, flattering photos of the victims with lovely music, and and what do you call it? Like passionate arguments about how justice for the girls is the most important thing. No matter how many times that they'll do those sorts of things, the fact remains that there never was compelling evidence in regards to the guilt of Richard Allen. And that's just is what it is. There's no getting away from that. Families cannot get away from it. Law enforcement cannot get away from it. And the prosecutor cannot get away from it. And I think they're all angry. It's very clear after you've observed sentencing uh, from the statements made at the post-sentencing press conference by Doug Carter and some of the family and others, to the statements made in the various PR press campaign rounds and interviews that members of the state police investigative team and state actors basically have come out, all the things they've said, the family. In all ways, it's very clear that they are all very upset that the public's not buying it, that the public is not supporting them any longer, and that the public is upset and sees through uh, this heavy handed prosecution with a minimal amount of evidence. And so they'll never be able to get past that. And so they're probably going to have to change gears. The lashing out at the public, the sort of combative attitudes of the family and the state actors, those things are going to have to change. Uh, or I should say, it would be in their best interest to change that approach or to realize how they're coming across to the public, because the public is seeing through it all. The public's not liking it, and it's not doing anything to ingratiate themselves um, to the public, who is sitting with skepticism and asking, why have you hidden so much? Why have you destroyed so much? Why have you so maliciously brought actions against all the parties? I mean, you've brought actions against YouTubers, retaliative actions against other investigators like Todd Click in the case, and against the attorneys. And they've also done it to Richard Allen's wife alone. Remember what they did to her. I mean, you guys have you already forgotten all of the nasty claims made about the wife of Richard Allen? So they have just done so many things that reek of desperation, of bad faith. Um, the fact that they had to threaten to kill YouTubers, to try to run off YouTubers, to arrest Todd Click, and to slander and lie about the daughter and the wife of the accused. It's just horrible. It's been a utterly disgraceful attempt at I mean, it reeks of defensiveness, honestly. And since when do the parents of murder victims and prosecutors and law enforcement have to be so defensive? So I don't expect them to change. I expect more of the same. But my suggestion is it would be a good look to alter your course because it's been very obvious that you are all angry that no one's buying your shit anymore. So, with that being said, let's get into it. Okay. So, we're going to learn a little tonight about the Indiana court rules because I think this is a very important place to start. Because if we don't understand this, we won't understand even what we're discussing. So, keep in mind, we are discussing, in general, motion to correct error. What is a motion to correct error? When does it come into play? When is it mandatory? How do you file it? You know, what can happen? How can it be granted? Et cetera, et cetera. So let's learn about motion to correct error. And keep in mind, this is taken directly from the Indiana court rules, or rules of trial procedure. Okay. So take note, a motion to correct error is not a prerequisite for appeal. Okay? Except when a party seeks to address one, newly discovered material evidence, including alleged jury misconduct. Let's stop. I know I can't even make it through a whole sentence, but just before we get the ball rolling, you may remember when the juror came out, oddly enough, through murder sheet. Oh, what are the odds? What are the odds? There's no coincidences in Delphi, guys. But when that juror came out and said the things that she said, remember there was a huge uproar in the community regarding suspicion of alleged juror misconduct. And I wonder if the defense attorneys have really plumbed out all of that because I think it's still an open-ended question. Was there juror misconduct? I mean, it kind of seemed like it. But I'll leave that for the attorneys to do because, like I said, hey, I'm a public commentator. That's all. Okay. But jury misconduct and newly discovered material evidence capable of production within 30 days of final judgment, which, with reasonable diligence, could not have been discovered or produced at trial. Or, two, a claim that a jury verdict is excessive or inadequate. Now, let me just say that I would say that I think it's very reasonable, at least in my mind, that this jury verdict is excessive based upon two things. One, the weight of the evidence presented, which was thin, okay? And second, the exclusion of all that was excluded by this judge. And keep in mind, there was a lot of evidence excluded, okay? We're not just talking about the 70 days of deleted law enforcement product that may have been exculpatory and may have been able to be used as evidence. But we're also talking about forensic evidence from the state that was excluded, that should have been included. Like the geofencing, like the questionable social media breadcrumbs, like third-party theories of the crime, like what was included in the Franks memorandum and others, the Kagan Klein, the Tony Klein, the Ron Logan. Okay. Any other issues and grounds for appeal appropriately preserved during trial may be initially addressed in the appellate brief. Filing of motion. The motion to correct error may be made by trial court or by any party. C. Time for filing. The motion to correct error, if any, must be filed not later than 30 days after the entry of a final judgment is noted in the chronological case summary. The time at which the court is deemed to have ruled on the motion is set forth in TR 53.3. D. Errors raised by motion to correct error and content of motion. Where used, a motion to correct error need only address those errors found in Trial Rule 59A1. Okay. Well, 59A1 is what we just read, so let's go back to that. Newly discovered material evidence, including alleged jury misconduct, capable of production within 30 days, that could not have been discovered or produced at trial. Any error raised, however, shall be stated in specific rather than general terms, and shall be accompanied by a statement of facts and grounds upon which the error is based. The error claimed is not required to be stated under or in the language of the basis for the motion allowed by this rule, by statute or by other law. Okay? So once again, because we're going to look at this, any error raised shall be stated in specific rather than general, and shall be accompanied by statement of facts and grounds upon which the error is based. Statement in opposition to motion to correct error. Following the filing of a motion to correct error, a party who opposes the motion may file a statement in opposition to the motion to correct error not later than 15 days after the service of the motion. That's what McClellan filed in state's response. The statement in opposition may assert grounds which show that the final judgment or appealable final order should remain unchanged, or the statement in opposition may present other grounds which show that the party filing the statement in opposition is entitled to other relief. Okay, so that's understood? All right. Motion to correct error granted. Any modification or setting aside of a final judgment or an appealable final order following the filing of a motion to correct error shall be in an appealable final judgment or order. Yeah, do you get that? Pardon me. Hold on. All right. Thank you, Mark. Thank you, Mark. But did you get that? That's very important too. And I was going to say this later when we get to the actual document, but the deal here that I'm getting at is this is all going into record, right? This is the amazing thing. Okay, so to hit the reset, we can all pretty much predict what Gull is going to do here. Okay, let's pull this down and talk to the people. We can pretty much all predict what Judge Gull is going to do. It's going to be consistent with what she's always done. Okay, but to hit the reset button, what really matters here is this goes into record for appeal. Okay, so as we get into what we're going to get into now, let's remind ourselves that now we're entering record. Okay. Thank you, Mark. I will keep up. Okay, let's see. Shall be an appealable final judgment or order. See? Okay. Cross errors. If a motion to correct error is denied, which we predict, The party who prevailed on that motion may, in the appellate brief and without having filed a statement in opposition to the motion to correct error in the trial court, defend against a motion to correct error on any ground and may first assert grounds for relief therein, including grounds falling within sections A1 and 2 of this rule. In addition, if a notice of appeal rather than a motion to correct error is filed by a party, the opposing party may raise any grounds as cross errors. So see, I guess I'll skip this because basically what I feel my interpretation of reading this paragraph G here is that this has sort of forced McClelland's hand, right? So this is better done than not. And for that, I give all due credit to Andy Baldwin. This is better being done than not done because this forces McClelland's hand now and then forces the judge to order on it now rather than allowing it to be open-ended and it possibly come up later and then allowing McClelland to have some sort of way of addressing it which cannot be predicated at this point in time and forced a judgment or order from go like is going to happen now. So I'm pretty optimistic about this paragraph G here. Anyway, it says, if a notice of appeal rather than a motion to correct error is filed, the opposing party may raise any grounds as cross errors and may also raise any reasons to affirm the judgment directly in the appellate brief, including those grounds for which a motion to correct error is required when directly appealing a judgment under sections A1 and 2 of this rule. Motion to correct error based on evidence outside the record. Now, everyone heads up here because as you're going to learn, let me remove this banner. Okay, as you're going to learn here shortly, this is the actual relevant paragraph here, okay, of this court rule. All right. So this is the section here where we need to be particularly attentive. Motion to correct error based on evidence outside the record. So remember what Baldwin said, as was quoted in the article that I just read, okay? When a motion to correct error is based upon evidence outside the record, the motion shall be supported by affidavits showing the truth of the grounds set out in the motion. And the affidavits shall be served with the motion. If a party opposes a motion to correct error made under this subdivision, that party has 15 days after service of the moving party's affidavits in motion in which to file opposing affidavits. Well, we skip that. It doesn't matter. It's been done. Now, here, number 3. If a party opposes a motion to correct error made under this subdivision, the party has 15 days after service of moving parties' affidavits in motion in which to file its own motion to correct error under this subdivision and in which to assert relevant matters which relate to the kind of relief sought by the party first moving to correct error under this subdivision. No reply affidavits, motions, or other papers from the party first moving to correct errors are contemplated under this subdivision. Okay. Cost. The trial court in granting a new trial may place cost upon the party for who applied for the new trial, or a portion of the cost, or it may place costs abiding the event of the suit, or it may place all costs or a portion of the costs on either or all parties as justice and equity in the case may require after the trial court has taken into consideration the causes which made the new trial necessary. J, relief granted on motion to correct error. Okay. Now this is another place to perk up your ears. So hopefully you paid attention to H because we'll be referring to it again. But here on J, relief granted. The court, if it determines that prejudicial or harmful error has been committed, shall take such action as will cure the error without limitation, including the following with respect to all or some of the parties and all or some of the errors. So you understand that part. All or some of the errors. So it doesn't have to be a broad stroke. It could be just one of the pertinent parts of the motion to correct errors. That's another thing to keep in mind as we go forward. But grant a new trial, enter final judgment, alter, amend, or modify or correct judgment, amend or correct the findings or judgment as provided in Rule 52B. Remember, 52B says the motion to correct error. Well, sorry. I have to go back to that. So let's skip that. In the case of excessive or inadequate damages, enter final judgment on the evidence for the amount of the proper damages, grant a new trial, or grant a new trial subject to additor or remitter. Grant any other appropriate relief or make relief subject to condition, or grant any other appropriate relief. Grant any other appropriate relief or make subject to condition, or in reviewing the evidence, the court shall grant a new trial if it determines that the verdict of a non-advisory jury is against the weight of the evidence, and shall enter judgment subject to provisions herein. If the court determines that a verdict of a non-advisory jury is clearly erroneous, as contrary to or not supported by the evidence, or if the court determines that the findings and judgment upon issues tried without a jury or with an advisory jury are against the weight of evidence. In its order correcting error, the court shall direct final judgment to be entered, or shall correct the error without a new trial, unless such relief is shown to be impracticable or unfair to any of the parties, or is otherwise improper. And if a new trial is required, it shall be limited only to those parties and issues affected by the error, unless such relief is shown to be impracticable or unfair. If a corrective relief is granted, the court shall specify the general reasons therefor. When a new trial is granted because of the verdict, findings or judgment do not accord with the evidence, the court shall make special findings of fact upon each material issue or element of the claim or defense upon which a new trial is granted. Such findings shall indicate whether the decision is against the weight of the evidence, or whether it is clearly erroneous as contrary to or not supported by the evidence. If the decision is found to be against the weight of the evidence, the findings shall relate the supporting and opposing evidence to each issue upon which a new trial is granted. If the decision is found to be clearly erroneous as contrary to or not supported by the evidence, the findings shall show why judgment was not entered upon the evidence. Orders regarding service, programs, or placement of children alleged to be delinquents or alleged to be in need of services. No motion to correct error is allowed concerning orders or decrees issued pursuant to Indiana Code Sections 31, 34, 47E, etc., etc. Appeals of such orders and decrees shall be prescribed or proceed as prescribed by Indiana Appellate Rule 14.1. Okay, so we'll be back to this. All right, so all right, so good news for you guys. What we're going to do is cross-reference as we go through this. Okay, pardon. All right, so it says, the defendant, Richard Allen, comes before the court for the reasons that follow. The court should strike the state's response to the motion to correct error in its entirety. And hey, you listen, I know it's easy to side with the defense in this, especially if you're prejudiced favor the defense, angry at the state, etc. But let's say this. Let me say this. I would have to agree entirely with this because that state's response to the motion to correct error was absolutely infuriating. It was warrantless or baseless. It was paper thin. I mean, there was nothing to substantiate the claims. There was a lot of gaslighting, a glossing over pertinent details, not directly addressing. It's status quo from Nicholas McClelland. But like I said, do you honestly expect the judge to be reasonable or in any way unbiased in this case? I don't think so. I mean, even Mike Patty had to acknowledge and has now twice on video that she did what she had to do to ensure a conviction. So the state's response is unverified and without supporting affidavits asserts numerous facts outside the record in violation of Trial Rule 59H2, which provides if a party opposes a motion to correct error made under this subdivision, the party has 15 days after service of the mooting party's affidavits and motion in which to file opposing affidavits. A motion to correct error under Trial Rule 59H1, unsupported by affidavits, presents nothing for the court to consider. That's your precedent, Murrieta versus Romero, 225. Now listen. So let's review that claim, okay? So what is he saying here? He's saying it's unverified. The state's response to the motion to correct error is unverified without supporting affidavits and asserts numerous facts outside the record in violation of 59H2. Okay. 59H2. 59H2, what does it state? If a party opposes a motion to correct error made under this subdivision, the party has 15 days after service of the mooting party's affidavits and motion in which to file opposing affidavits. When a motion to correct error, number one, is based upon evidence outside the court record, which this you'll shortly find out is, the motion shall be supported by affidavits showing the truth of the grounds set out in the motion. The affidavits shall be served with the motion. So what's the gist of that? The gist of that is that McClelland's entire response to the motion to correct error is unverified because it brings out claims that are not in the record, that are unsubstantiated, or that are not backed with affidavits. Okay, so let's continue and we'll explore that. In particular, okay, so let's pay attention. Okay, not to be patronizing, but you guys know what I mean, okay? In particular, on page 2 of the state's response, McClelland alleges on November 3rd, 2022, the state received an email from attorney Brett Gibson stating that he would not be representing the defendant. Herein attached to State's Exhibit 3. That allegation is based on facts outside the record and unsupported by affidavit or verification. Okay, let's look at it. Okay. Here is page 2. And here in G, well, no, actually they're referring to H. On November 3rd, the state received an email from attorney Brett Gibson stating that he would not be representing the defendant herein. attached as State's Exhibit 3. Okay, so when we looked at State's Exhibit 3, it's an email. Let me see if I have it. I didn't prepare all those exhibits for you, but we showed them in the last. It's basically, it's a printout of an email. Okay. But it is not an affidavit, okay, or verification. Furthermore, he states on pages 7 to 8 of the state's response, McClellan alleges the defense received the van video and any information pertaining to Ron Logan included in Mr. Allen's motion to correct error on January 30th, 2024. That allegation, Mr. McClellan asserts, is supported by State's Exhibit 7, a discovery release. These allegations are based on facts outside of the record. True. And unsupported by affidavit or verification. True. Okay, so let's look at it. We're going to go piece by piece here. All right. So McClellan here, page 7. That this evidence, along with the video surveillance evidence from the residence, was received by the defense on January 30th, 2024, as evidenced by the discovery release herein attached as State's Exhibit 7. Okay. Well, you remember that because we did a whole exploration of this. But again, according to this trial rule here, we're looking for exhibits from trial. Okay. From the record. Well, clearly, this being discovery but not admitted into trial as evidence means it's not on the record. It's outside of the record. That checks box 1. And it's unsupported by affidavit. That checks box number 2. Okay, but let's take a little detour. And I hate to be annoying with this, but because I think it's so important, I'm going to indulge myself here. Please indulge me. Oh, Tammy Martin, I must confess, I do the same thing. I probably did the same thing before I started the show. Yeah, I suck. The double stuff Oreos, they suck. They suck. Okay. What do I want to say about this? Okay, this was the receipt. Okay, this is from Discovery. This is the physical discovery release that we went through ad nauseum because it's so concerning. So let's just take a little detour and remind ourselves of the import of this. Right? It's very, 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 very important in my opinion. Let's see if I can explain it. Okay, I have it here for you. Let's see. Let me pull it up in this form. Oh, I actually didn't get it ready. Let's see. I can read it. I can read the parts that I'm obsessed with here. Okay. Page 4. Remember here at page 4 that on this Western Digital 3.5-inch 500 gig drive, it contains I'm sorry, 170226 Delphi flip phone, which to me I would interpret as February 26, 2017, February 26, 2017, Delphi flip phone found under bridge. Delphi flip phone found under bridge. And then March 11th, 17, Delphi LG phone. February 22nd, 2017, HTC white chip off report. Alec B boat. Amazon tablet with the pink case. And why does it say Woods? Woods. Are we fucking kidding ourselves here? Guys, I really hate I don't enjoy being that dramatic, but here's what's concerning to me. Let's read it. Let's read it again before I show you. Amazon tablet X43Z60 pink case Woods. Okay, let me ask you this. What does this look like? Remember when I said that I put filters to these photos? I played around with the exposure, the contrast, all of that. Remember when I said that? And do you know what was the odd thing? I could turn this thing pink. I could turn this thing pink. Look at the exposure. Okay, look at how odd the exposure is because it's a nighttime photograph with flash. Anyhow, who knows? Who knows? The point is, we're just moving. let's move on. Okay. But back to this. Let's see. Libby German, Samsung, Galaxy Tab. I mean, that's like 4 or 5 right there. 4 or 5 devices right there. And why would it say Woods? Pink case Cassandra Nelson Woods. Okay, I'm getting I'm getting a little sidetracked. Let's get back to this. Well, that particular model of the tablet is a 7-inch tablet, which is about the size of a phone. All right. Oh, where am I? Next page. On page 8 of the state's response, McClellan says Reese Davis is interviewed by law enforcement, which he was, as is shown by defendants' exhibits 4A, 4B, and 4C. But Mr. McClellan also says Mr. Davis requested a polygraph exam, which he failed miserably. No exhibit of Mr. Allen says anything about a polygraph examination. These allegations by Mr. McClellan are based on facts outside the record and unsupported by affidavit or verification in violation of Rule 59H2. All right, so let's look at it. Once again, he says, polygraph failed miserably. Not in the record, unsupported by affidavit or verification. In E here, he says, law enforcement interviewed Reese Davis and submitted him to a polygraph at his request. That Mr. Davis failed polygraph miserably. Mr. Davis gave the statement that alleged Ron Logan confessed to him that he killed the older girl first and then took the younger one away from the scene, that he killed the second victim later, then brought her back to the scene, that he went back to the scene after search parties searched his property and moved the girls to another location, that he removed the cell phone battery from the girl's phone and left the phone behind, and that he took the girl's clothing from the scene and burned. Many of these details are directly contradicted by evidence. The others have no evidentiary support. Okay, those are claims. Those are claims. But it appears that Mr. Baldwin is correct here. They're not in the record. They're unsupported by affidavit or verification. Additionally, now this is a slammer here. This is a bomb here. Look at the footnote here. The tip in the Orion database, Defendants Exhibit 4A, does recite verbatim. Logan told Reese how he burned his clothes in a fire pit and where it was located. Logan told Reese how he burned his clothes. But McClellan says, McClellan says, where is it? Page 8? McClellan says, he took the girl's clothing from the scene and burned. Okay. He removed the cell phone battery from the girl's phone and left the phone behind, and he took the girl's clothing from the scene and burned. So what are we left to hear to take? McClellan's willy-nilly word. Do we take McClellan's willy-nilly word that He alleges, Reese Davis says, Logan said that he burned the girl's clothes. But the tip in the Orion database, Defendant's Exhibit 4A, recites Logan told Reese how he burned his clothes in a fire pit where it was located. But again, nothing anywhere says anything about Logan confessing to taking a battery out of a phone. And let me just do an aside here. I explained in the last show or two how absolutely impossible that is. Okay. There's no way you're taking a battery out of an iPhone. Not Ron Logan in the woods on the spur of the moment. Like let's be serious here. Okay, I owned a iPhone 5 and iPhone 7. My son owned an iPhone 6. I'm very familiar with that series of iPhones. I'm so familiar that I had to order specialty kits to disassemble those iPhones in order to do little repair work or anything I wanted to do with them. They're very tiny screws. It's not the easiest thing in the world. You have to have special wedge tools and the whole 9 yards, suction cup to take the screen off. It's not easy. I'll tell you now, Ron Logan absolutely did not take a battery out of an iPhone. Now, if one of those girls was carrying some other kind of phone, hear me. If one of those girls was carrying some other kind of phone, yes, a battery could have been taken out of some kind of other phone, some Android, some Motorola flip phone, or there's some other phone. Well, it leaves you to question, was there another phone? Is there another phone? Did Ron Logan take a battery out of some other phone? Let's be real here. Okay. While the court might take Mr. McClelland's misstatement of fact about the burning of clothes as simply a mix-up, either McClelland is making up the allegation about Logan removing a battery, or he has access to information about Ron Logan's confessions to Reese Davis he has not shared with the defense. In either event, there's reason to cite Trial Rule 59H2, which requires affidavits in support of a response to a motion to correct error when that response is based on evidence outside the record. Again, H2, what does it say? If a person or if a party opposes a motion to correct error made under the subdivision, that party has 15 days after service. Okay. Of the moving parties, affidavits, and motion in which to file opposing affidavits. All right. I'm not trying to belabor the point, but we're trying to thoroughly understand the claims that are being made by both sides here and which ones have substance, which do not. Also on page 8 of the state's response, McClelland states, no evidence places Ron Logan at the scene of the murders. This allegation by Mr. McClelland is based on facts outside the trial record and unsupported by affidavit or verification in violation of H2. And I would agree. On page 9 of the state's response, McClellan says Sergeant Cecil was able to observe photos of the phone when it was found. Herein attached to state's exhibits 9, 10, and 11. In addition to not saying whether Sergeant Cecil actually observed these photos, this allegation by Mr. McClellan is based on facts outside of the record, unsupported by affidavit or verification, in violation of Rule H2 again. 59H2, unsupported. And here's where the money is, okay? Remember we said money. This is money. And it's actually hilarious. This I think it's sort of a rib I mean, understand, okay? Understand that Mr. Baldwin has a reason to be angry. Understand that. They did try to have him arrested and jailed along with Mr. Rossi for this, okay? Understand, Baldwin has a reason. They tried to throw him in jail. So he has a little reason to be a little butthurt here. The court might want to consider footnote number 2 here. Whether to hold McClellan in direct criminal contempt for publicly filing crime scene photographs the court had ordered sealed at McClellan's own request. See Hopping v. State 637. Where, as here, the court has hand and immediate knowledge of acts demonstrating a clear disregard for its authority, which threaten to undermine the integrity of the judicial process, summary proceedings for direct criminal contempt are available. The power of Indiana courts to summarily punish for direct criminal contempt, while specified by statute, rests upon common law. It is inherent in the courts. Alternatively, under Indiana Code 3447.3.1 and 3447.3.5, the court might consider issuing a rule to show cause why McClellan should not be held in indirect criminal contempt for his willful violation of an order of the court. And what was that violation again? Remind me, Prof. Please remind me. Oh, sure. I'll remind you. That in order to hide, let's be real here. Okay, once again, hold on. Let's be real. In order to hide from the public the fact that those girls had sticks placed on their bodies in geometric formations resembling an attempt to form bind runes, which is unambiguous. There's no doubt about it. Remember, even the state's own witness and an ISP officer asserted that those sticks only covered 3% of the bodies, although McClellan tried to gaslight you all and say that whoever killed these girls, Richard Allen, was attempting to cover the bodies. When you had pounds of leaf litter all surrounding the area, you had more sticks at their disposal. There could have been burying of those bodies under leaf litter and sticks, but that's not what actually happened. Those sticks were placed in specific formations with clear right angles, clearly an attempt, either directly or indirectly, to form bind runes. In other words, either as part of some ritual or part of setting up some individuals who would perform such rituals. Wiccan, Satanists, Odinists, Vinlanders, whatever you want to call them. But in order to keep the world from ever being able to recognize that fact, McClellan asked the judge, and of course she complied, to seal those photographs. Which is why all of you need to share them. Every single one of you need to get your hands on those photographs and share them so the world can see that there's something wrong at that crime scene. But McClellan cast a wide umbrella and said all the photographs from the autopsies and the crime scene. And then he files his state's response to the motion to correct error. And what does he do? He shows you, or he gives you, his own sealed photographs from the crime scene. These were under seal. But he's doing it because he thinks he can act with impunity, without consequence, when it behooves the state to present such evidence. So they are trying, with these photographs, to discredit Stacey Eldridge's contention or assertion or affidavit in which she says that she saw no sign of water damage or dirt on the phones or on the phone. So what he's trying to do is he's trying to show you moisture on the phone and possibly dirt. So he says, I'm going to release these to discredit Stacey Eldridge. All right, let's continue. On page 10 of the state's response, in subparagraph 4L, Mr. McClelland says, quote, there is nothing in the logs, reports, or extractions that would indicate whether or not the phone had some kind of water damage, because that kind of damage is not registered in the logs, reports, or extractions of the phone. Whether or not there was water damage can only be determined by physically examining the phone. Mr. McClelland is not an expert and attempts here to testify as if he were one. And this pleading is not his first attempt. Every single allegation of this subparagraph quoted above is based on facts outside the record and unsupported by affidavit or verification in violation of Trial Rule 59H2, at least on McClelland's part, because remember, when Baldwin and Rozzi, when this was provided here, Stacey Eldridge did provide an affidavit. Okay, so that's the thing. This particular filing here, the defendant's Richard Allen verified motion to correct errors, was substantiated with affidavits and verification. McClelland's is clearly not, and it's not even an argument. It's here in black and white for you. We're showing you. All the allegations above, based on facts outside the record, which they are unsupported by affidavits or verification. They are crucial to the state's response to the motion to correct errors because the absence of supporting affidavits or verification by Mr. McClelland violates Trial Rule H2. The state's response should be stricken in its entirety from the record of this case. And like I said, believe this, regardless of what Gull does at this point in time, this is going into appellate or into the record for the appellate court. So this will matter. This will matter. This is a conundrum now for the state. In addition to alleging facts outside the record of the case without supporting affidavits or verification of the facts in his own motion, Mr. McClelland repeatedly misstates the law and therefore misleads the court. Well, what's new about that? I mean, they misled the jury, so why not allow to mislead the court? Let's be real here. On page 2 of the state's response, Mr. McClelland says that the statute governing safekeeping orders Indiana Code 3533.11.1, does not require the court to have a hearing to make this determination. The court can make this determination based on the motion alone. He repeats this assertion on page 3, saying Judge Diener was, quote, within jurisdiction of the statute to make ruling on the safekeeping motion without a hearing. But this cannot be so because, as set out in Mr. Allen's verified motion to correct error on page 6, under the next section, Indiana Code 3533.11.2, Mr. Allen had an absolute right to refuse transfer to the DOC because then Sheriff Lesenby had only alleged the safekeeping request was to protect Mr. Allen's personal safety. How could Mr. Allen have exercised that statutory right if the court could make a factual finding based on then Sheriff Lesenby's motion alone? The state's response does not explain how there was any evidence before the judge from which he could make a factual finding without a hearing to support his safekeeping order, because then Sheriff Lesenby's motion was unverified. He could not have, and Mr. McClelland's interpretation, for lack of a better word, of the statute is completely unsupportable. At pages 2 and 3 of the response, without denying that he knew Mr. Allen was represented by Brett Gibson, Mr. McClelland attempts to make much of Mr. Gibson having not filed an appearance for Mr. Allen. On page 3, for example, the state's response says, as of the filing of the motion for safekeeping, the defendant did not have an attorney of record. The complaint should strike the court as odd, because Mr. McClelland appeared at Mr. Allen's initial hearing on October 28, 2022, and filed the state's verified request to prohibit public access to a court record the same day. Remember, we spoke about that yesterday. No, we spoke about it in my show called, geez, it's been that long ago, 3 days ago, the need to intervene for transparency. Okay. In my show called DELPHI, the need to intervene for transparency, we discussed how on October 28th, McClelland requested that the entire court record be sealed, because I was saying to you that from the very beginning, there's been zero transparency. But McClelland filed the state's verified request to prohibit public access to a court record on October 28, 2022, with no service of that motion on anyone, not Mr. Allen nor his attorneys. Even though he knew Mr. Allen was represented by Mr. Gibson. And on November 22nd, 2022, Mr. McClelland both filed his request for what became known as the gag order and appeared for the state at the hearing on his request to prohibit public access to a court record. But oddly enough, now you guys, I know my voice gets monotone. You may not be listening. Listen to this. Although McClelland appeared at Mr. Allen's initial hearing and filed the state's verified motion to prohibit public access, and on November 22nd filed his request for the gag order and appeared for the state at a hearing on his request to prohibit public access to the court, he did not file his own appearance in the case until November 23rd, 2022, almost a month after he initiated the case. It's apparently enough that everyone knew for a month that McClelland represented the state without his having an appearance on file. But then it's insufficient for McClelland and Sheriff Lesenby to have known that Mr. Allen was represented by Gibson, regardless of Mr. Gibson's not having filed an appearance. Hey, that's unbalanced, unfair. It's good old boy shit. 101. All right. Now, on pages 5 to 6 of the state's response, McClellan says the presumption of prejudice from U.S. v. Chronic is only applied in cases of non-representation throughout the entire case. Smith v. Brown (2014). Apparently, Mr. McClellan is acquainted with footnote 25 of Chronic, which unambiguously says, quote, "The court has uniformly found constitutional error without any showing of prejudice when counsel was either totally absent or prevented from assisting the accused during a critical stage of the proceeding." Critical stage. And Smith v. Brown, the Seventh Circuit case Mr. McClellan relies upon, says nothing different. Quote, "In Chronic, the court explained that presuming prejudice would be appropriate in the face of a complete denial of counsel or denied at a critical stage of the litigation." It's really not debatable that Mr. McClellan has, at best, misunderstood Chronic. But I would say no, it's not misunderstanding. It's interpreting the law in a way that is only beneficial to your argument, which is what McClellan has done consistently throughout this. Our recent cases make clear that contrary to the Court of Appeals conclusion below, denial of counsel at any critical stage of a criminal prosecution is per se constitutional error. Thomas v. Kemp. On page 6 of the state's response, McClellan calls the van video defendant's Exhibit 3A at best impeachable evidence. That is not so. Agent Pohl's testimony about a prior inconsistent statement by Brad Weber would have been merely impeaching. However, the van video is substantive evidence of when Brad Weber arrived home in his van. See Pritchard v. State. Under the silent witness theory, video recordings and photographic evidence may be admitted as substantive evidence. More importantly, first let's get down to this footnote here. Also on page 6, McClellan says defendant's Exhibit 3A, the van video, is in the form of a YouTube link that is not identified as an item of evidence by the ISP number, and therefore is an improper submission for consideration by the court. In fact, as Mr. McClellan must know, Mr. Allen properly filed the video file that is defendant's Exhibit 3A with the court on a thumb drive. Mr. Allen also properly served the state with the exhibit in the same way. The web link was provided in Mr. Allen's motion to correct error simply for ease of viewing by the parties and the court. Mr. Allen is unaware of any requirement that his exhibits be identified by an ISP number, especially when the video recording was provided to the defense, again, as McClellan must know, without such a number. Okay, so are we getting that? It's defendant's Exhibit 3A. So it's in the record. Okay, it's in the record. And it was supplied. So attempting to poo-poo it for not having the number is again, it's demonstrative of bad faith at best. More importantly, on page 6 of the state's response, McClellan erroneously asserts that a motion to correct error only applies to newly discovered evidence. Actually, Trial Rule 59H, by its own terms, provides for motions to correct error based on evidence outside the record. And that's what I want to drive home to you all. Evidence outside the record, not newly discovered evidence. The rule says nothing about newly discovered evidence. Defendant's Exhibit 3A, the van video, is evidence outside the record. Mr. McClellan has no answer to Mr. Allen's claim under Napui v. Illinois. Mr. McClellan knew or should have known that Brad Weber's testimony, critical to the state's case presented to the jury, that he arrived home in his van at 2:30 on February 13th before Liberty German's cell phone stopped moving at 2:32 was false. Mr. McClellan did nothing to correct Mr. Weber's testimony, knowing it to be false. Napui states a conviction must fall when the state, although not soliciting false evidence, allows it to go uncorrected when it appears. Listen, they knew that Brad Weber arrived home after that time. The FBI knew it. The video comes from discovery, meaning it comes from the state, meaning it comes from the investigation. They knew about the video. They knew the time of the video. They knew about the FBI sheet with the phone pings, which corroborate the video. Don't get that twisted either. Don't get it twisted. The FBI sheet regarding the phone pings of Brad Weber corroborate or align with the video of the van arriving home a mere 3 to 5 minutes earlier than the ping. Don't get it twisted. The state knew that. The investigators knew that. If they didn't know it, they are obliged or obligated to have known it. But in order to make this whole Monica Walla, Richard Allen getting scared by the white van or by the van work, they had to push that timeline ahead by 15 minutes to make that work. And think about this. If that van passes at 2:30, that only leaves 2 minutes to get through that goddamn creek that's chest high, frigid, and flowing with 2 little girls. You got to be real. You got to get real here. Get real. How on earth do you get across that creek, ushering 2 little girls against their will to do so, and get your own ass across that creek, down the one bank, across the creek, up the other bank, which is very steep and muddy and slippery and all this shit, to the spot where this phone ends up in 2 minutes? But then you don't hightail it out of there. You linger around and kill 2 girls when you know. Listen, if any of you have been to that scene, you would know that Brad Weber can see Ron Logan's backyard. It makes 0 sense. No sense at all. If Brad Weber pulled up in a van, scared Richard Allen and 2 girls across the creek, he gets there. Brad Weber's still in a line of sight to where they end up on the other side of that creek in this hypothetical scenario. He would not have killed those 2 girls there, knowing that Brad Weber can still see a line of sight. And even if Brad Weber had already pulled in and gotten out of that van, from Brad Weber's property, you can look down upon that crime scene. So what kind of logic and what kind of sense does it make that you're frightened off by a van. You usher these two little girls across that frigid, rapid flowing creek up to the other side of the bank. And then instead of hightailing it out of there and getting the fuck out of Dodge so that you don't end up arrested, you end up killing those two girls in direct line of sight. Where's the screaming? Simple answer, it didn't happen. Mr. McClellan did nothing to correct Mr. Weber's testimony, actually allowing him. A conviction must fall when the state, although not soliciting false evidence, allows it to go uncorrected when it appears. It's irrelevant whether the defense knew about the false testimony and failed to object or cross-examine the witness, because defendants cannot waive the freestanding ethical and constitutional obligation of the prosecutor as a representative of the government to protect the integrity of the court and the criminal justice system. God, that's a good one. Please take note of that. That's Sivak v. Hardison. It is irrelevant whether the defense knew about the false testimony and failed to object or cross-examine the witness, because defendants cannot waive the freestanding ethical and constitutional obligation of the prosecutor as a representative of the government to protect the integrity of the court and the criminal justice system. Oh, but not in this court, because this is a railroading, buddy. There's no constitution. I told you guys this was important news. Everything above about the defendant's Exhibit 3A, the van video, meaning the van arriving home, applies equally to defendant's Exhibit 3E, the FBI subject information sheet for Brad Weber, which also shows Mr. Weber arriving home. This FBI subject information sheet shows Mr. Weber's cell phone first pinging at his family's house at 2:50 p.m. on February 13, 2017. On page 7 of the state's response, Mr. McClellan says, the subject information sheet for Mr. Weber is not newly discovered evidence, and at best, impeachable evidence. Defendant's Exhibit 3E is substantive evidence of when Mr. Weber returned home in his van. And because it was in the state's possession, Mr. McClellan either knew or should have known Mr. Weber's testimony that he returned home about 2:30 p.m. was false. Again, like I said, it's a double down. It's a confirmation of the video. It's a corroboration. It leaves two burdens on the state. Keep in mind, this FBI subject information sheet and the video of Mr. Weber's van arriving home constitute two obligations on the part of the state to know and correct the timeline in Mr. Weber's testimony. Mr. McClellan either knew or should have known that Mr. Weber's testimony that he returned home at 2:30 was false. And as with the van video, Mr. McClellan did nothing to correct Mr. Weber's false testimony. Mr. McClellan, in fact, seems to be under the misimpression that all his evidence is substantive, while contradictory evidence presented by the defense is merely impeachable. State that again, because this is another devastating argument that Mr. Baldwin is making, and it's poignant. It's poignant. Mr. McClellan has consistently, this has been from the beginning, it's not just for this motion to correct error. This has been a consistent fact, and honestly, from the authoring of the PCA in 2022. Okay, from that PCA until now, Mr. McLean has been under the misimpression, and that goes for Mr. Leggett, that goes for Mr. Lesenby, that goes for Judge Diener, that goes for Fran Gold. This entire contingent has been under the impression that their evidence is substantive, while contradictory evidence is merely impeachable or merely nothing. It's just nothing. All our shit is grand. All of your shit is nothing. It's been from day one. Remember, this sheriff, he took the descriptions of 4 to 5 different vehicles and twisted them all into one vehicle, Richard Allen's. And the one vehicle that he could not morph into Richard Allen's Ford Focus, that 1965 Comet looking vehicle, he omitted from the probable cause affidavit. From day one, they have been doing this. Do you know what's another new discovery? Let's take a little break from this. Another new discovery is that blue jacket that they seized as part of that search warrant at Mr. Allen's home. Are you ready for this? It was purchased after 2017. Fact. We now know it to be fact. Is there any wonder why there's no victim's blood on that jacket? Because he wasn't wearing it in 2017. Oh, but it was used to secure a search warrant and an arrest. It was used to brainwash the public and to mislead the jury. And you know what I would venture to say? I would guess that bullet was not his either. I'd be willing to bet $500 right now that bullet ain't Richard Allen's bullet. I mean, he got no blood in his car. He got no blood on his clothing or his boots. He got no blood on the jacket. The jacket wasn't even purchased until 2018 or later. Let's see, what else? You got no digital forensics. You got DNA on the bodies, but it ain't his. I'm trying to remember. What says Richard Allen killed these girls again? What evidence? Literally zero? Literally zero evidence. Zero. Remember, when they exercised that search warrant on that property and they took all this shit and that shit in the other and the blue jacket, do you remember when Rick Snay said that he asked Kathy Allen, hey, Kathy, when they came with that search warrant, did they take any box cutters? Oh, no. Question: did you have box cutters? Oh yeah, sure. Did they take box cutters? Oh no. You're starting to see how things add up. Like I said, they reverse engineered a case against Richard Allen. And they started with the gaslight that they had always done. Oh, it's not a group of people. It's not a group of people that killed these girls who are known to us. No, no. It's Bridge Guy. And Richard Allen now is Bridge Guy. Mr. McClellan seems to be under the misimpression that all his evidence is substantive, while contradictory evidence presented by the defense is merely impeachable. This is of a piece with his idea that actual cell phone data showing headphones were plugged into and unplugged from Liberty's cell phone hours after 2:32 p.m. And remember, I told you only a matter of minutes before that third phone left the geofencing indicates that the data was caused by dirt or water damage. All because that data would otherwise disprove the entire case he has presented. The entire timeline goes away, just like Brad Weber makes the entire timeline go away. But that data that someone plugged the headphones into and then hours later unplugged the headphones from Liberty cell phone disproves the entire case, and everyone is supposed to assume that the case he's presented must have been accurately portrayed. Finally, the one affidavit McClellan does have supporting the state's response is State's Exhibit 5, executed by Tobe Lesenby. Oh, and this is rich. This is rich. We're coming full circle to what I mentioned earlier. The problem with that is Lesenby's affidavit directly contradicts, at least twice, his sworn testimony at the safekeeping hearing held June 15th, 2023. Let's say that again for those in the back who don't understand that these people have perjured themselves on the stand more than once. The problem is that Lesenby's affidavit directly contradicts at least twice his sworn testimony at the state safekeeping hearing, which was held June 15, 2023. First, in his affidavit, Lesenby says that Mr. Allen was transferred to White County Jail on October 28th, 2022 because of overcrowding at the Carroll County Jail. See State's Exhibit 5 at paragraph 4. At the safekeeping hearing in June of 2023, Lesenby explained Mr. Allen's transfer to the White County Jail as follows. Question: and so tell the court what arrangements you made to have him placed in White County. Lesenby answers, just a matter of simply having direct communication with Sheriff Bill Brooks and explaining my concerns of potential safety and security of our facility, and ask him if he could temporarily hold Mr. Allen for us. Question: okay, and were you confident that Mr. Brooks and his facility was adequate to hold him on a temporary basis? Answer: at that time, yes. Hold on. Wait. Your concerns were of potential safety and security, not overcrowding. Huh. From the transcript, page 16, there's not a word about overcrowding at the Carroll County Jail being the reason that Mr. Allen's transfer to the White County Jail happened. In his affidavit, Lesenby also says that Judge Diener, quote, at no time gave me legal advice on the motion pertaining to safekeeping. Again, in his affidavit, Judge Diener at no time gave me legal advice on the motion pertaining to safekeeping. In the first instance, Lesenby is not competent to say whether Judge Diener gave him legal advice. In the second, Lesenby unambiguously said Judge Diener adjusted the language in Lesenby's safekeeping motion. Oh, yeah. We've beat that one into the ground, and we'll probably will some more, because that's a very concerning episode to me regarding Diener. Question. All right. Is that the motion that I've just alluded to? That was filed by you, signed by you, filed back in November of 2022. Yes, sir. Did you draft this motion yourself? Actually, says Lesenby, I had presented a similar motion to request, I should say, to the court. And as I recall, the court had actually come up with or provided this particular document. Okay, so let me see if I can ask a more direct question. Did you prepare that motion in your office on a computer, essentially? I prepared a similar motion to this. Again, the wording was adjusted by the court. Yeah. Yeah, and you know what else he said? Because maybe we forgot that. Let's see if we could pull that up. Who asked you to sign this? The court. Who is the court? Judge Diener. Okay. Adjustments were made by the court. Okay, did you provide the court any additional documentation? See, this is where the attorneys actually did a good job. They actually did a good job because they were seeking to understand whether this was verified or unverified. And look, he actually confesses that it's unverified. Okay. Did you provide the court any additional documentation in support of these allegations before the document was finalized? No. Okay, so the way I understand it is you didn't offer up any supporting documentation at all, other than just your thoughts about a high-profile case in the media. Yes. All right, you seeing a pattern here? And this is what we're talking about here. Notice what it says, okay? Pay very close attention. Look at the heading. Request by the sheriff of Carroll County, Indiana, to transfer inmate from custody of the sheriff to custody of the DOC. I am duly elected sheriff. You see that? Now, how appropriate is it for Judge Diener to author this? For Lesenby to present to sign and then present to him in his own court for him then to issue a judgment on. Leaving aside the improper ex parte communications between Judge Diener and Lesenby, adjusting the word of the motion, quote unquote, adjusting the wording of a motion to be filed in his own court on which he would be ruling obviously constituted both reviewing and drafting a document, which the Indiana Judicial Conduct Rule 310 prohibits, except for family members. And reviewing and adjusting the wording of a motion is most fundamentally the giving of legal advice, which Rule 310 also prohibits. Mr. McClelland solicited from Lesenby an affidavit, which is right here, saying Judge Diener had not given Lesenby legal advice. Look at it. It's number 7. It's number 7. That the court at no time gave me legal advice on the motion pertaining to safekeeping. You notice how he admits, or he omits, apologize for the, I'm tired here. Do you notice how he omits the fact in his affidavit that Judge Diener authored and then asked him to sign that safekeeping request here? He omits that. And this is the order that Diener goes ahead and issues on his own request. This is unbelievable. When I say it's the good old boy shit. And remember, this is where he cited the maelstrom of public interest and the bloodlust and we're not safe. And he gaslights the shit out of the entire public. And then he immediately recuses himself because he knows he fucked up. Yeah. Mr. McClelland solicited from Lesenby an affidavit saying Judge Diener had not given legal advice when Mr. McClelland damn well knew, or should have known, that was not true, simply not true. Listen, McClelland was present. Okay, let's go back because I'm fucking determined to make my point here. Guys, McClelland was present. Sorry. When this happened, did you draft the motion yourself? Actually, I presented it to the court and a similar motion, and he drafted it. Then he asked me to sign it. Then I gave it back to him without any verified documentation. McClelland was present. Sorry. Of course he knew that it was not true, this affidavit. Look at the affidavit. So let's present that again. So in other words, McClelland allowed an affidavit which he knew to be false, which is not all that different from letting Brad Weber's false testimony about the timeline go uncorrected. In sum, the violation of Trial Rule 59H2, the crucial facts on which the state's response depends on, are outside the record. They're also unsupported by affidavit or even verification of the response itself by Mr. McClelland. The state's response also pervasively misstates the law and therefore misleads the court, just like they misled the jury through the entire trial. Finally, the one affidavit the state did submit in support of its response alleges facts Mr. McClelland knew to not be true. For all these reasons, the court should order the state's response stricken from the record. Okay, submitted by Andy Baldwin. Today. Okay, let's show you that. This is today. Today. Once again, what does H2 say? If a party opposes a motion to correct error, then the party has 15 days after service of the moving party's affidavits in motion in which to file opposing affidavits. Okay. Well, state's motion. All right. I don't know how much more any of this matters because, it's not going to matter. It's not going to matter. She's going to just continue the standard. But let's take a look. Let's see. Just a moment, please. Ooh, excuse me. Whoa, what is wrong with me? Okay. All right. Let's see. Let's see. I wanted to take a quick look. Just for a friendly reminder, for those who may have missed part one. Now, if you missed part one, please go back and see part one if you're interested. Now, part one states, in summary, the following. We'll go quickly through them without deep dives. But remember that these first 2 pages are the most important here. Um, in violation of the 6th and 14th Amendments, Mr. Allen was deprived of counsel at a safekeeping proceeding, November 3rd. The proceeding was a critical stage at which Mr. Allen was entitled to be represented. Okay. 3533.11.1 governs safekeeping proceedings for pretrial detainees and provides in full that the court, sheriff, prosecuting attorney, defendant, counsel, attorney general, in other words, pretty much anyone, alleging that an inmate in a county jail awaiting trial is in danger of serious bodily injury or death or represents a substantial threat to the safety of others, the court shall determine whether the inmate is in imminent danger of serious bodily injury or death or represents a substantial threat to the safety of others. If the court finds that the inmate is in danger of serious bodily injury or death or represents a substantial threat to the safety of others, it shall order the sheriff to transfer the inmate to another county jail, to a facility of the DOC or whatever. Okay, for the purpose of this chapter, an inmate is not considered in danger of serious bodily injury or death due to illness or other medical condition. Yeah, or crowding, right? Remember the overcrowding that Lesenby tried to cite. But as Baldwin said here, more importantly, 353311.2 also governs safekeeping proceedings for pretrial detainees and provides in full the inmate or receiving authority is entitled to a post-transfer hearing upon request. The inmate may refuse a transfer if the only issue is his personal safety, which it was. Now, question for you out there. Okay. Do you honestly believe that what is it, June of, geez, I can't even remember, 2023, June 15th? Do you honestly believe that waiting until June 15th of 2023 was sufficient to require this opportunity, or to sufficient as fulfilling the requirement for the opportunity for Richard Allen to refuse? I don't know if you're understanding what I'm saying. Hopefully so. The inmate may refuse. Okay, may refuse. November 3rd until June 15th. All right, so what else is in here that we need to quickly? And like I said, in here, an important point in here also is the concept that Diener authored, which would be about probably page 5. Okay, this paragraph here. Mr. Allen had the right to have a judge other than Diener decide whether to issue the safekeeping order because Judge Diener had engaged in ex parte communications helping to draft the safekeeping request in violation of Rule 310. He also violated Rule 29. Okay. Judge Diener was obligated under Rule 211 to recuse himself, which he did. But guess what? He was obligated to recuse himself and request appointment of a special judge before the issuance of the safekeeping order that he drafted, not after, or the safekeeping request. So before the decision on the safekeeping request, he should have recused himself before that safekeeping hearing is the bottom line, because he authored the request for Leatherby. Okay. Fourthly, Leatherby's safekeeping request was not verified. There was zero evidence. Remember that. Okay, remember that. And then we're going to move on to here, which is page 8, which was the next major point, which is that in violation of the Due Process Clause of the 14th Amendment in Napui v. Illinois and its progeny, the state presented testimony of Brad Weber that Mr. Weber arrived home in his white van about 2:30 on February 13, 2017, knowing that the testimony was false before it was elicited or failing to correct it. So we've touched on that. So that's the next point, the major point here. Like we've already covered it. They knew that to be false. Okay. The next little aspect here is a Ron Logan alleged confessions as related by Reese Davis. Okay. And as I've mentioned before, I don't think that there's anything to it. I think it's all malarkey, except for this place here. Page 17. Okay, page 17 here. Pulled box cutter out. Slit oldest one, hit an artery. Which would be proof that for years, the concept of a box cutter being used was out in the public. Just like for years, the concept of a van, in particular, a white van, being in Weber's driveway and at Weber's home was known and discussed. Both points, box cutter and van, are supposed to be things that only the killer would know. Well, both points are things that Monica Walla could have obtained knowledge of by surfing Reddit or the Discords or talking behind the scenes and all the things that we knew she was doing. She could have easily obtained those nuggets of this story about a box cutter and the public knowledge of a white van. She could have easily carried that right back to Richard Allen and colored his alleged confessions with those nuggets. And for me, that's what's important about this whole thing, Reese Davis. I don't believe a word of it. I think it's shallow. I think it's inaccurate. I think there's probably other reasons he was giving this information. But the bottom line is that in this information, a box cutter is discussed. And remember, that Dr. Kaur, he never mentioned a box cutter until the second meeting with Nicholas McClellan in the past year, when magically he had an epiphany and said, oh, you know what? I guess since Monica Walla has said that Richard Allen has mentioned a box cutter, I guess I should say that it's the potential that a box cutter could have been used in this murder. Oh, Prof, but that would mean that there's a conspiracy and people are lying, more than one. That is what it means. You're right. You're so perceptive. All right. Next up. Hey, but at least this is not lost. Okay, at least this is not lost on Andy Baldwin, because he even says here. Look at what he says here. He says, under the circumstances, Dr. Kaur's trial testimony about a box cutter possibly being used on the two girls makes Ron Logan's confession newly discovered evidence. So he's even aware that there's there's a questionable aspect of this. By bringing up the box cutter, and it's just magically Dr. Kaur just comes up with the box cutter after falling off the toilet, hitting his head on the floor like the professor in Back to the Future. He had an epiphany. He was squeezing one out on the toilet, and he strained too hard, and a blood vessel burst in his head, and he had a magical sudden epiphany about a box cutter, just coincidentally about the same time that he had his second meeting with McClellan, and Dr. Monica Walla had been able to let's say get a confession-like statement out of Richard Allen involving a box cutter. Okay, and here we go with Stacey Eldridge. Says that dirt or water damage to the phone could not have caused the auxiliary jack on Liberty's phone to log wired headphones plugged in and wired headphones unplugged. Ms. Eldridge's expert opinion is newly discovered evidence. Okay. And in particular, the big point here is nothing in the data on Liberty's phone indicated there had been water damage. None of the reports or extractions related to Liberty's phone created by law enforcement officers reflect dirt or water damage. Photographs of Liberty's phone taken by the Indiana State Police did not show the phone to be wet, dirty, or covered by debris. Now, question for you. Do you think that that is why McClellan released these? See, he's trying to counter Stacy's affidavit. Furthermore, Miss Eldridge is unaware of any scientific or technological research suggesting that water or dirt damage to an iPhone would cause the phone to inaccurately log wired headphones in or wired headphones out. Okay? But uh, remember though, that according to First Sergeant Cecil, he Googled by the seat of his pants. He ran out and quickly Googled uh, a Google search. And according to him, the Google hearsay told him that in its expert opinion, Liberty cell phone showing wired headphones in, wired headphones out could have been caused by I keep saying wort, dirt or water damage. Yeah, it's rich. It's rich. So that's pretty much the substance of the Richard Allen's verified motion to correct errors, and the state's response to the motion to correct errors, and the defendant's verified motion to strike the state's response to the motion to correct errors. So if you are interested and would like to go back and get even more in that, you can look at the DELPHI motion to correct error. Which we've covered, we've covered. So let's see. So I think that at this time, I'm going to take a break and call it. This was a good show. All right. So there's a lot to think about there, and I would like to thank Mr. Baldwin for filing that. I think it's really informative. I think the major takeaways are that all the points addressed, contrary to McClellan's opinion, are not trial evidence. They're also, all the claims McClellan made are unverified and not supported with affidavits. And like I say, I never do totally shill for the defense. I'm not going to support every single thing they say or do, but I have to say that I think this one is well substantiated. It's on a much more solid foundation, of course, than McClellan's. It's all there in black and white, and like I said, you got what we've done today. I don't even know if you remember here, but let's look at what we've done today just for a quick review. Okay, we've looked at the this one, and we've compared it to the state's response that it is addressing, and we've also compared it or referenced it to the original motion to correct error. We've also paid particular attention to the Indiana Rules of Trial Procedure, Rule 59, especially Section H2, which is being cited numerous times. But as at the beginning, we went through all of this, and I said how it's pretty interesting here, especially in the first Section A. Okay, a motion to correct error is not a prerequisite for appeal, but A party can address newly discovered material evidence, including alleged jury misconduct. Okay. Or claim that jury verdict is excessive or inadequate. So we went through all of that. We also looked at the receipts that would be good reference points with the photographs of the device that they are claiming is Liberty's iPhone, which I must say, it's not a rose gold iPhone in a Harry Potter case. That's clear. Okay, so what I've determined about that phone so far, it's probably an iPhone, but it's not Libby's iPhone. Although it could be a 7-inch tablet, possibly. The case does not appear to be red. It appears to be purple or pink. Depending on how you filter it, you can get it purple, you can get it pink, and all shades between, but you can't get it red or any other color. We've also looked at the safekeeping request that Judge Diener authored and had Tobe Leazenby sign. And then, oddly enough, later decided on it in his own court and issued an order, and then recused himself. I mean, just it's all ugly. And I think some of the major touch points in this are the fact that McClellan, aside from all of that, he allowed evidence he knew to be false or at least misleading to be put forth. And that being Leazenby's affidavit, claiming that there was no collusion with Judge Diener, and most concerning, Brad Weber's timeline, which he should have known based on the FBI information sheet cross-referenced with the video of the van arriving home with a timestamp. So, cheers to all of you. Now listen, I did promise you that tonight we are going to do a little review of a past show. So momentarily, I'm going to get some refreshments, get something to eat, and refresh myself, and then I'm going to premiere, or I'm going to stream a show in special memory of Abby and Libby for you guys. You're going to love it, and it's going to be quite a long, interesting show. So I'm going to put that on for you. I'm not going to be on the screen, but I'm going to be in the live chat. So within an hour or so, hour or less, get ready. I'll make another stream, and we're going to look at the truth about Delphi. Okay? So God bless you all. Hug your kids, hug your wife. It's been good to see you all. I'm excited to see this. We've got other documents too. So we'll be getting back together on a live stream in the next few days and covering some more information. But until then, God bless you all. Special shout out and thanks to the amazing Mr. Mark Ellis for the super chat, the Mr. Dennis McKean for the super chat, and the lovely Miss Deb, Miss Indy Cindy, Miss Low Light Recovery for all the memberships, because Low Light Recovery gifted 5 memberships. Hopefully some of you got those. Karen Stearns, the lovely Karen Stearns became a member. The lovely Indy Cindy, renewed her membership, and the lovely Miss Deb became a new member. So happy for all you new members. Please check out the train guy video in the members only video section. And for those of you on the replay, please, and thank you for Miss Mino Dino for starting the bribe. What does that mean? Are you Mr. or Miss Mino Dino? But thank you to Mr. or Miss Mino Dino for the super chat as well. And for those of you on the replay, please check it out at the top of the live chat and also tagged on the channel. I have the Cash App and the Buy Me a Coffee. Those are my support pathways. Please support the channel. In addition, please hit the like. I'd really appreciate that. And if you're on the replay, leave some comments down below. Always appreciate the comments. I love to see them come in. God bless you all. Thanks to the new members. Thanks to the supporters, the Cash Appers, Super Chatters, Buy Me a Coffeeers, and chocolate purchasers, and the swear jar. All right, appreciate you all. And everyone in the live chat, all my regulars, okay, and the mods, especially Hebby Brown and Kayla and Amy, my 3 main mods. Okay, appreciate you all. So see you later. All right, God bless.